Hi, I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning technology, intellectual property and corporate law firm that's unique in that we do both front-end advisory work and we also litigate in these specialist areas of practice. So in this video, I will discuss a case involving copyright infringement in software and just how much evidence is enough for a party to decide whether or not to initiate legal proceedings in the federal court. So in this video, I will cover how an order for discovery can be made in the federal court before legal proceedings are initiated, just what happened in the case of Qudos Mutual Limited versus Infosys Limited in 2019 in the federal court, which was decided in May 2019, that I'll refer to as Qudos Mutual, and the information that the respondent or Infosys was ordered to provide because of Qudos Mutual's successful application for discovery. So it does seem strange. How can an order be made for discovery prior to initiating proceedings? This is especially so when you understand the differences between the discovery procedures in the state and the Federal Court of Australia. So in the Federal Court, Rule 7.231B of the Federal Court Rules 2011, which I'll refer to as the rules, allows an order for discovery to be made prior to commencing proceedings. In doing so, the prospective applicant needs to satisfy the court of four matters. Firstly, that the applicant needs to reasonably believe they have a right to obtain relief from the prospective respondent. In other words, that they have a case. Secondly, before applying to the court, the applicant needs to have made reasonable inquiries to determine that they in fact have sufficient evidence to decide whether or not to start legal proceedings. Thirdly, the applicant has to reasonably believe that the prospective respondent does or is likely to have control of documents that are directly relevant to whether the applicant's right to the relief exists. And finally, that inspection of those documents would assist in making the applicant's decision to initiate proceedings or not. So if the court is satisfied of these four requirements, it will order the prospective respondent to give discovery. The kind of documents that may be discovered are mentioned in subparagraph 1CI of Rule 7.23. There's a lot of rules. So just what happened in the case of Qudos Mutual. This case was decided in May 2019 and was ostensibly a disputed discovery application. It's a fairly recent case. It involved whether the prospective applicant, Qudos Mutual, already had enough information under Rule 7.23 to make a decision to initiate proceedings. The decision provides insight into how much evidence is enough and the importance of precisely complying with orders made in cases involving copyright infringement in software. So the background. In brief, Qudos Mutual was looking to transition to a new, fully integrated banking platform. So in March 2015, it engaged Infosys to provide a range of programming services pursuant to a Master Banking Services Agreement, an MBSA. Everything has an acronym, doesn't it? Eventually, the relationship between the parties deteriorated and Qudos Mutual issued a notice of termination of the MBSA. By this time, Infosys had produced what looked like similar software for the Australian Military Bank, or AMB. Qudos alleged that Infosys had breached the terms of the MSB, including the contractual obligation of confidence, and infringed its copyright by developing software for AMB. Qudos wanted to commence proceedings on these grounds, but wasn't sure whether or not it had enough evidence to do so. Because of this, it filed an originating application seeking orders pursuant to Rule 7.231B for production of documents by Infosys. Infosys didn't provide the documents in accordance with the agreed orders made in December 2018, or the December orders. However, Qudos thought this evidence was sufficient for it to decide whether to initiate proceedings. The documents provided to Qudos pursuant to the December orders included a copy of the source code underlying AMB's UX, records of design meetings between Infosys and AMB employees to the design of the UX, also the disclosure of wireframe drawings, emails and design works produced in those meetings, any design brief AMB provided to Infosys, and finally, documents recording the design inputs and the wireframe drawings that AMB had provided to Infosys. As required by the December orders, Infosys did provide the source code, but provided a different version which was different from the one which was required by the orders. Qudos argued that a different version was provided it could not properly compare Infosys' updated source code to determine whether or not there was a substantial reproduction. Note that the test for whether there is a substantial reproduction is much more than completing a side-by-side comparison of the code in the case of software. We discussed the test for substantial reproduction in another video called What is a test for substantial reproduction of computer code? But in this case, Infosys argued that the information it provided to Qudos was enough for it to decide if they should initiate legal proceedings. They argued that Qudos could not rely on the preliminary information just to feel comfortable before making a decision when it already had sufficient information to make that decision. Justice Burley considered that there were a few things which established a causal connection between the two sets of code. However, Justice Burley thought this was still not enough information to assess whether the A and B code was a substantial reproduction of the Qudos code. Because of this, Justice Burley ordered Infosys to further provide the source code of Qudos' testing website, which was hosted by Infosys. This contained a copy of the online banking platform developed by Infosys for Qudos as part of their initial MSBA. Infosys was also ordered to further provide the source code of the online banking solution that Infosys developed for AMB, including a revision history up to that date. So what to take from this? So in relation to applications for preliminary discovery of a copyright infringement in source code, the infringer may be required to provide the entirety of their source code. An order for discovery may be granted on the basis that a prospective applicant does not have information to decide whether there was a reproduction of its source code. Importantly, this means that a prospective respondent or defendant, like Infosys, will be required to provide a version of the source code as it was when the alleged infringement happened, as opposed to any subsequently updated versions. In this day and age, when version control and code repository software is the norm, it seems futile to attempt to provide a different version of the source code in an attempt to thwart a complainant's application. But what I must say is that really the risk is there's little risk with large organisations, but a lot more risk with smaller ones. So if you're looking for a technology-savvy law firm to advise on a litigious matter involving copyright infringement in software, or if you have a dispute regarding a software development project, please don't hesitate to call me on 3221 0013 for an obligation-free and confidential discussion. Thanks for watching. Video adjourned.